This courtroom hearing starts with something judges absolutely hate: a defendant showing up late, again. And from the very first seconds, you can already feel the tension building. The judge wastes no time calling it out, and what begins as a simple attendance issue quickly turns into a serious warning about jail time, warrants, and courtroom accountability. But that's only the surface of what's happening here. As this case unfolds, we're going to see a defendant facing allegations tied to fraudulent use or possession of identifying information, a state jail felony carrying potential prison time, heavy fines, restitution demands, and years of supervision hanging over her head. The courtroom atmosphere shifts back and forth between stern legal procedure and surprisingly human moments, including awkward pauses, missing paperwork, jokes from the bench, and even confusion over a thrift store t-shirt. But don't let the lighter moments fool you. Beneath all of that is a very serious criminal case involving multiple alleged victims, financial consequences, and a plea deal that could permanently impact this defendant's future. Watch closely because the judge is paying attention to everything: punctuality, attitude, understanding of rights, and whether this defendant is truly taking the process seriously. What makes this hearing fascinating is how quickly things escalate. One minute the judge is talking about tardiness, and the next she's discussing felony punishment ranges, waived constitutional rights, restitution, and possible incarceration. And throughout the hearing, you can sense the court trying to balance fairness with frustration. The biggest question is this: was the defendant simply overwhelmed and disorganized, or has the court already started losing patience with her? Stay until the end because the judge's final decision, and the conditions attached to it, could determine whether this defendant walks toward rehabilitation or straight into far more serious consequences. And trust me, there are several moments in this hearing where one wrong answer could have changed everything instantly.
All right, why are you late for court?
Today,
Yes.
I think I was on time. I sat in the wrong chair.
No, you were not in this courtroom because I call the docket every day at 9. So why were you late? So I have an issue with you. You were late today, and I have an issue on the docketing sheet that you were a no-show for the last setting. So here's the thing. If you want me to help you be on time, I can help you with that. And you know how I'll accomplish that? You'll be coming over from the Bexar County Jail dressed in blue. And where is
You
Kelly?
want her to know that as well?
Yes. Brenda, what page is this on?
For me?
Sorry?
For this one right here?
Yes. Ah,
You found it?
yes. Oh, you guys need to switch.
Okay.
Why were you late and why are you this is the second time you've been late for this court. I'm not going to tolerate it anymore. Why were you late?
Ma'am, I was downstairs in the line for about 10 minutes.
All right, so here's the thing. You're going to have to make plans for lines and all of that. You understand? Because this is the second time. I'm not going to tolerate that anymore. What's going to end up happening is a warrant is probably going to be issued for your arrest. You understand?
Right away, the judge is establishing something every courtroom operates on: punctuality is not optional. To viewers at home, being a few minutes late might not sound like a major issue, but in criminal court, especially when there's already a reported no-show on the docket sheet, it can seriously damage a defendant's credibility. Judges often interpret repeated lateness as disrespect for the court or a sign that the defendant may not comply with future orders. Notice how the judge immediately references the possibility of jail transportation dressed in blue. That wasn't just sarcasm, it was a warning. The court is basically saying, if you can't show up voluntarily on time, we'll make sure you arrive in custody. That's a powerful message this early in the hearing. What's also interesting is that the defense immediately pivots into discussions about other pending cases, video evidence, and requests for continuances. That tells you this defendant's legal situation may be broader and more complicated than what we're seeing in this single hearing. And here's a question for you. Do you think courts should be this strict about tardiness, or should judges allow more flexibility when someone claims delays outside the courtroom cause the issue? Let me know in the comments because courtroom discipline is one of the most debated parts of the justice system.
And if you're taken into custody, we will make sure you're on time. Or at the very least, we'll know where you are. All right, where are we on this case?
Judge, on this case, we've been conferring this morning with Mr. Sanders. She has a few other cases and we wanted to ask your permission that they've not been indicted. One's a misdemeanor and two unindicted. We wanted to ask the court's permission to return on Thursday to give us a chance to review.
All right, Ms. Ferguson, if we can recall this on Thursday, the 8th. All right, we'll see you on December 8th at 9 a.m.
Thanks, Judge.
All right, Ms. Ferguson, we'll give you a reset form.
Your Honor, this is the first setting on her case, and I would like to request a reset of about 30 days to be able to review all the video that are on it.
Okay, have you conferred with the state?
I told, yes, just to talk about that I needed to ask for more time.
Okay, and state, did you make an offer or no?
No.
Okay. All right, so is there a lot of video in this case?
There is.
Really?
There was at least 10 officers. There's like 4 pages of how many videos.
All right, Ms. Ferguson, can I have a 30-day reset on Kelly?
Brianna Kelly. Okay,
All right, it's gonna be December 5th, and I showed that you were a no-show on August 23rd. At least that's what's written here on the docketing sheet. What page is she on the page 15? All right, why are you late for court?
Today,
Yes,
I think I was on time. I just sat in the wrong chair.
no, you were not in this courtroom because I called the docket every day at 9. So why were you late? So I have an issue with you. You were late today, and I have an issue on the docketing sheet that you were a no-show for the last setting. So here's the thing. If you want me to help you be on time, I can help you with that. And you know how I'll accomplish that? You'll be coming over from the Bear County Jail dressed in blue. So do you want that?
Come in.
Then if you are late again, that's what's gonna potentially happen to you. Do you understand?
Okay.
The judge repeating the warning a second time is extremely significant. Courts usually don't like repeating themselves unless they want the warning clearly preserved on the record. In other words, if the defendant shows up late again in the future, nobody will be able to say she wasn't warned. This is also one of those moments where you can feel the judge trying to prevent a bigger problem before it happens. Instead of immediately issuing a warrant or ordering custody, the court is giving the defendant one more opportunity to prove she can comply. That's actually more lenient than many people realize. Some judges would have escalated much faster after repeated attendance problems. At the same time, the courtroom dynamic becomes almost uncomfortable because the judge is publicly emphasizing accountability while the defendant keeps offering explanations that don't fully satisfy the court. You can practically feel the frustration building. And honestly, moments like this matter more than people think. A defendant's behavior outside the actual criminal allegations, showing up late, interrupting proceedings, ignoring instructions, can absolutely influence how the court perceives their reliability moving forward. It may not determine guilt, but it can shape trust, and in plea negotiations or sentencing decisions, trust matters a lot.
All right, we're coming back on December 5th at 9 a.m. And Ms. Ferguson, if you can highlight and circle 9 a.m. for Ms. Kelly, please. They'll give you a reset form.
Thank you, Judge.
You're welcome.
Yes.
Court is calling 2022 CR 11569W, State of Texas versus Brianna Elizabeth Kelly. Could I have parties announced for the record?
Marcus Sanders.
Dancing Preview representing Ms. Kelly for Sean Brown's office.
All right. And are you Ms. Kelly?
Yes, ma'am.
Hi, what does your T-shirt say?
Mud hens.
Mud what?
Hens.
Oh, mud hens. Okay. All right, counsel. I'm going to show you what's entitled discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. I'm always interested when I see T-shirts because I'm wondering where they come from, which
Sounds like
state.
the name of a team.
Yes, is that the name of a team?
I got it from the thrift store.
Okay. No, I like it because at first I thought it was maybe related to mud bugs, which is Louisiana fair. So Brenda, that's what I was thinking. All right, I'm going to show you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Next, I'm going to show you what's entitled Waiver of Indictment, Reader of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that document with your attorney? Did
Yes,
you
ma'am.
understand it?
Yes,
And did you sign it?
yes, ma'am.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict?
Yes, ma'am.
Did you understand your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Now we move into one of the most legally important parts of the hearing, the waiver of rights and plea process. The judge is carefully confirming that the defendant understands exactly what rights she's giving up by entering into this plea agreement. And this isn't just courtroom formality, it's constitutionally required. When the judge explains rights like jury trial, confrontation of witnesses, and the ability to remain silent, she's making sure the plea can't later be challenged as uninformed or coerced. Once a defendant knowingly waives those rights, it becomes much harder to undo the plea later. The charge itself is also serious: fraudulent use or possession of identifying information. Even though this specific case involves fewer than 5 identifying items, it's still classified as a state jail felony. That means the consequences can include incarceration, supervision, financial penalties, and a permanent criminal record. What stands out here is how calm and procedural the hearing feels despite the stakes being incredibly high. The judge methodically walks through each document, ensuring the defendant verbally acknowledges understanding every step. That protects the court legally, but it also protects the defendant by making sure there's no confusion. And viewers should pay attention to one major detail. The judge reminds the defendant that the court does not have to follow the plea agreement. That's huge. Many people mistakenly believe plea deals are automatically guaranteed outcomes, but judges still maintain final authority in many situations.
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes,
Court will find that defendant has knowingly and voluntarily waived and consented to waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Showing you what's entitled Information. Did you review that document with your attorney? Did you understand it?
yes, ma'am.
Counsel, do you waive the reading of the information?
Judge.
State, are you proceeding on the information as presented? Next, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of fraudulent use or possession of identifying information less than 5 items as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes,
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
We've discussed what's happened, Judge, and decided to go forward today.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Judge, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do believe that.
Miss Kelly, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
yes,
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
yes, ma'am.
All right, according to the plea bargain agreement, punishment is to be assessed at 2 years in the state jail facility. There's no application for deferred adjudication. State recommends community supervision. This will run concurrent with cause number 691768.
This section suddenly reveals the true scale of the case. Up until now, the hearing felt procedural, But once the court begins reading the restitution terms and naming multiple alleged victims, the broader impact becomes much more visible. Restitution isn't symbolic. It's the court ordering repayment for losses connected to the alleged criminal conduct. The sheer number of names, businesses, and entities involved suggests investigators believe this case affected multiple people and possibly multiple incidents. We also hear references to Walmart, property companies, and various individuals, which paints a picture of a case that may have involved financial fraud or identity-related offenses across several contexts. What's fascinating is the courtroom's tone during this moment. Even while discussing serious restitution obligations, there are brief human moments, confusion over names, pauses, and even slight laughter. That contrast is something you see often in real courtrooms. These proceedings can swing from tense to awkward to procedural within seconds because everyone involved is still human. But legally speaking, restitution can become one of the hardest parts of a sentence. Prison time eventually ends. Financial obligations sometimes follow defendants for years. So while people often focus on incarceration, the long-term financial burden attached to felony cases can completely reshape someone's future.
State will take in consideration 2022 CR 6341B, GJ 768492. And Brenna, are you ready?
Judge, I just gave her a copy of.
Okay, thank you. I'm going to read it as exactly as it is, Brenna, without tripping over names, hopefully. Restitution is to be determined by the court through the Community Supervision Office. There's to be restitution to Anna Velasco, Draco Jackson, Lorena Grazgorowski, Arturo Saenz, Samuel Estrada, Cecilia Gonzalez, Maribel Gonzalez, Judgement Woods, Nyla Rojas, Damian Reyes, and payable to victims under grand jury number 768492, SAPD number 220262228, Richmond Properties, 2022 CR 6341B, Metropolitan Construction. There's to be no contact with Walmart at 5555 De Zavala Road, Richmond Properties, Metropolitan Construction, Anna Velasco, Draco Jackson, Lorena Grazgorowski, Arturo Saenz, Samuel Estrada, Cecilia Gonzalez, Maribel Gonzalez. See, I don't think that J is pronounced. Djamon Woods, Nyla Joe Rojas, and Damian Reyes. There's a comma after Reyes. Is there supposed to be someone else? Or is Reyes the last person? All right. Did you understand that to be the plea?
Yes, ma'am.
Defense? Is that the
Yes,
plea?
That's their agreement. And I wanted to request a PSI judge to get that restitution determined before the sentencing if
You want
possible.
to turn me back the trial court certification
Okay.
then? All right. And Ms. Kelly, did you understand that to be the plea?
Yes.
Defense, is that the plea? Oh, state, that's the plea?
Yes.
All right. Show you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Here's another major legal moment that viewers shouldn't overlook: the waiver of appeal rights. By signing that paragraph, the defendant is dramatically limiting what issues can later be challenged in a higher court. That's why the judge spends extra time making sure the defendant understands exactly what's happening. Notice how the state is also requesting additional conditions like community supervision, evaluations, community service hours, restitution, and MRT programs. This tells us the prosecution may be aiming for a structured supervision outcome rather than immediate incarceration alone. In many felony plea situations, courts try to balance punishment with rehabilitation measures designed to reduce future offenses. Then comes another critical decision. The defendant pleads no contest rather than explicitly saying guilty. A lot of people misunderstand that distinction. In practice, A no contest plea still allows the court to treat the defendant as convicted for sentencing purposes, but the defendant is not formally admitting guilt in the same direct language. And honestly, this is where courtroom viewers often divide. Some people believe plea agreements are practical resolutions that save time and reduce risk. Others think defendants accept them mainly out of fear of harsher punishment if they go to trial. What do you think? Would you risk trial or take the negotiated deal?
Yes, ma'am.
Counsel, are there any such motions? Next, I'm showing you outside the plea bargain agreement. They're asking that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 150 hours of community service restitution, CATS 1 and 2, and the MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State?
State offer states Exhibit 1 and it's.
We reviewed it carefully and have no objection, Your Honor.
All right, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments and review the same. Brenda, we're off the record for a moment.
Oh, Judge, I folded a page at the very back of the steps to show you exactly what the allegation is that's charged
Okay, no,
on top of that page.
all right, thank you. Can I see the paperwork on Marco Zavala? That was a plea. And thank you for doing that. I appreciate that.
I would have put a little sticker, but I didn't have one.
That's okay.
It's a long report.
All right. That was my concern. I was like, surely I'm not imagining things. With regards to this waiver and consent to stipulation of testimony, there's a whole page that's missing.
Oh,
Oh, it's my signature page. It's not in there. So I don't know if something has happened. It should be the certificate for the defense counsel. And then my approval. I don't know where that page went. Oh, do you need a stapler remover? Brenda, I don't know why men don't ask for a stapler remover. There's a page missing.
This entire section perfectly captures how unpredictable courtroom proceedings can become. Suddenly there's missing paperwork, confusion about signatures, discussion over evaluations, and even uncertainty about what type of supervision was actually requested. It may look messy to viewers, but moments like this happen more often than people realize in busy criminal courts handling massive caseloads. What's important is that the judge slows everything down instead of rushing through incomplete documentation. That matters because procedural mistakes can create serious appellate issues later. Even something as simple as a missing signature page can potentially complicate a conviction if not corrected properly. The judge also orders a PSI, a pre-sentence investigation. That's extremely significant because a PSI gives the court deeper background information before final sentencing. It can include criminal history, personal background, financial information, victim impact details, and recommendations regarding supervision or punishment. In other words, the final outcome is still very much in flux here. And then comes another revealing moment. The judge asks about drug testing. Questions like that aren't random. Courts frequently use them to evaluate compliance, honesty, and potential rehabilitation concerns before sentencing. One failed test can dramatically change how a defendant is viewed heading into the next hearing.
And I'm gonna need a PSI date for this case. And are we gonna need a TAP evaluation, Ms. Previty?
I think that would be a good idea, Your Honor.
All right. Thank you.
You said the 6th, Your Honor? Okay.
All right, we're back on the record. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication.
We only applied for probation.
Oh, you only applied for probation? Okay. Well, Brenda, it's just one of those days, isn't it? All right, the court is finding there's sufficient evidence to find you guilty. The court is finding you guilty. This will be set for PSI on February 6th at 9 a.m. The court will order a TAP evaluation and we'll need a full PSI with restitution. If you're drug tested today, what are the results going to be?
Negative.
All right. We can get you a drug test today, okay? All right, thank you. She'll need a drug test today. Do you need any water?
No.
Okay, all right, thank you. Here we go.
By the end of this hearing, the court has officially found sufficient evidence to support guilt, accepted the plea-related documents, and scheduled the case for a future PSI hearing where sentencing-related decisions will continue developing. But what really stands out in this courtroom session is the balance between procedure, pressure, and patience. The judge repeatedly emphasized accountability, especially regarding lateness and compliance, while also carefully protecting the defendant's legal rights throughout the plea process. We saw discussions about waived constitutional protections, felony punishment ranges, restitution for multiple alleged victims, supervision conditions, evaluations, and the possibility of long-term monitoring instead of immediate incarceration. At the same time, the hearing exposed how complicated criminal cases can become behind the scenes. Missing paperwork, overlapping cases, investigative evidence, victim restitution calculations, and sentencing evaluations all show that courtroom justice is rarely as simple as a quick guilty or not guilty moment. Every detail matters. One thing is certain. This defendant now faces serious legal consequences that could impact her future for years, and the court will be closely watching whether she follows every condition moving forward. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and legal drama coverage every week.
All right, who's here on